Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law group Ross, Lanier and Deifik.
Thank you, Morgan, for the introduction. Well, thank you for coming back on the show again.
Happy to be here.
So you want to tell us a little bit about yourself and your practice?
Sure. I'm with Ross, Lanier and Deifik, PA, law firm downtown, Don Ross, Suzanne Lanier, and we're downtown in the Capitol Bank building. I do real estate litigation, business litigation, and I've been board certified in real estate since 1990.
In downtown, where's that located exactly?
Well, almost everybody in Naples knows where Pastrami Dan's is.
Yeah.
So we're on the corner of 6th Avenue North and 41 in the Capitol Bank building, across from Pastrami Dan's.
That's great. Well, we're here today to talk about deposits. So when they do a contract, and there's various contracts we have in our state here, one local, they're putting money down on a particular property, and we want to explain to our viewers what that entails or what can happen in the various different contracts there are. So let's start with that.
Sure. I think what people need to know is as soon as they put a deposit down, it's also called a good faith deposit or
Right.
earnest money, they are putting money at risk. It is a legally binding contract. And they're putting money at risk because the seller is taking their property off the market and the seller is taking a risk. So people need to understand the circumstances under which they might lose that deposit. And you're right, there's three primary types of contracts that we see in the residential market as opposed to the commercial market. The FAR bar, which is a very common contract used throughout the state,
Right.
Developed by the Florida Realtors and the Florida Bar. And then there's the NABOR contract, which is the Naples Area Board of Realtors, works with the Collier County Bar and putting that contract together. And both of those are revised very frequently, so you have to keep up. And then the third type of residential contract we see are developer contracts, where someone who has developed a large subdivision
Right.
is selling in large numbers. And there's significant differences between the contracts.
So let our viewers understand that there's, to put a deposit down, both parties have to perform. And that's where their damages can come into play if one party doesn't perform or the other party.
Yes, and I think what's very important is to make sure, first of all, I hope people are working with a real estate agent, because a good real estate agent is going to guide them, shepherd them through the process. And they need to understand what their obligations are and what the time limits are for the obligations. One of the problems we see very frequently is people know, for instance, that they have a right to seek a mortgage or a right to inspect,
Right.
but they wait till the last minute. And they've overlooked the fact that the contract only gives them certain windows of time within which to perform. Now, a significant difference between the NABOR contract, the local Naples
That's right.
contract, and the FAR bar is the NABOR contract only makes time of the essence for closing. So everything else, there's a little bit of wiggle room unless people insist on the dates. The FAR bar contract is very specific, and it says time is of the essence as to everything in the contract, which means you got to jump when you're supposed to jump.
Right. So time of the essence, how long in our local board contract is there the leeway there? Day, 2 or 3, or when would you be really
Concerned? I would start getting concerned when you're a couple of days over. But what the seller can do, and I advise sellers to do, is they can make time of the essence. For instance, if the NABOR contract says you've got 15 days to get your inspection done.
That's right.
What the seller should do is write a very simple letter saying, we mean it. It is critical to us that the inspection be done within this period of time. It is critical to us, the seller, that various things be done within these periods of time that are designated on the contract.
No, I know you're on a flow there, but when you say a letter, what do you mean by that? I'm not used to that.
Well, so many people act by email.
Right.
That's true.
Okay.
And many of the contracts now recognize the significance of email.
That's right.
I'd like to see clients also do a letter, scan it, attach it to the email. It's easier for me to prove in court later because I'm a litigator, so I think along those lines.
Mm-hmm.
But often an email will accomplish the same purpose.
But wouldn't it be better, I hope I'm not getting off track here, but wouldn't it be better if they put that in with the contract?
Absolutely.
When they're responding to the contract?
Absolutely, they
okay.
can do that.
Okay.
Sure.
And there is places where you can write it in the
Absolutely.
contract. That would be the best way, or an addendum or whatever.
If certain time periods are important
to you or the seller, right?
Well, to either party.
Right. Mm-hmm.
You can put in under other terms and conditions that the time periods are critical and you're going to insist on them. And of course, it's going to be a whole different ballgame if you have a developer contract, if you're purchasing from a developer.
So tell our viewers a little bit about that.
Well,
if you can, in
sure,
a
yes,
short period of time, because they're that thick anyway.
Right, they are. And people are often intimidated by them. But I think the critical thing to know is that the NABOR contracts and the FARBAR, which for the general public are just the individual residential contracts, they're written to a large degree to favor the deposit being refunded to the buyer in quite a large number of instances. I think the NABOR is the most favorable to the buyer, but the developer contracts are not written that way.
No, they're not.
They are written to favor the developer. And I think the key instance that we see the most is people are accustomed to a financing contingency. In the ordinary contracts that we've been talking about, if the buyer's not approved for their mortgage, they just give the letter of denial of credit to their real estate agent, and generally they get their deposit back, after a few steps are taken.
Exactly.
But the financing contingency in developer contracts often say something quite different. They often say, if you are not approved for your mortgage, then you must bring all of your credit information to us. We will try and get you a mortgage through our preferred lender on whatever terms we can get you approved.
So it could be a high interest rate.
It could be a high interest rate, it could be a shorter term, it could be things that the buyer was not expecting.
That's very interesting. Is there any way of avoiding that? Usually the developers don't like to change their contracts at all. Is there a way of putting an addendum to that to cover yourself or not? Have you seen that?
I have seen that, and what I have noticed in all the years I've been in Naples is it really depends on the real estate market. If there are buyers lining up at the developer's door, it's not likely to happen. If sales are slow and the buyer gets counsel, they can sometimes negotiate changes in the contract. It never hurts to ask.
That's right, never. Well, we're going to take a little short break, and we're going to be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Thank you. Welcome back. We're just joking around here offset, huh? So let's talk about the process of deposits, getting them back, or
Sure. Well, as I mentioned before, it's not automatic. The escrow agent, whether it's the realtor or the title agent or the attorney, is not going to be able to release the funds until everyone signs a form called a termination of contract and authorization to disperse. Now, what happens is that people will differ on their interpretation of the facts. And so there's going to sometimes be an argument. And that's when a client will come into my office and ask me to assist them in either obtaining forfeiture from the buyer or getting recovery of their deposit, depending on whether they're the buyer or the seller. So the first thing that I do is I analyze. And this is something that I think individuals can sometimes do themselves and need to think it through. First of all, I look at, is there a binding contract? Now, I have many times had people come in believing that they have a binding contract,
right.
but in fact they don't. Either because everyone hasn't executed all the counter offers and changes,
Dated them.
right? Or because, for instance, when you're working with a developer, often what happens is the developer's sales rep signs at the bottom where it says for seller, but the contract says this is not a binding contract
So the developer signs it?
until the president of the developer company
Right.
signs. And what we used to see, I don't know that it's happening anymore, but we used to see developers do what we call pocket contracts, where they wouldn't sign the contract, they'd put it in a drawer, and they had a couple of different reasons. They weren't sure they were ready to start construction, or they thought maybe they'd get a higher offer on that unit, but for whatever reason, it hadn't been fully executed. So that's the first level of analysis.
So can I interrupt
sure.
you there? So the person comes in and they didn't realize that they weren't in a binding contract, okay? Could those, and I'm maybe off the track here, but could they go and bind it, or when they think there's going to be a problem, the developer, could they just sign it and then it becomes a binding
I've
contract?
actually had that happen, and what is critical is in order for a contract to be binding, there has to be not only execution but delivery. So if I execute a contract,
You have
I'm
to-
going to sell my house to you,
You-
and I put it in my drawer.
It's not executed.
No. So what I do in that instance is I make them prove delivery. Delivery had to happen before I sent my letter to you canceling the contract.
Okay, that makes sense. So it could be an email or it could be anything, right?
Sure.
Okay,
sure.
that makes sense.
So then the next thing that I do is I interpret the contract. And as we were talking before, there are certain types of contracts, and I'm, have a familiarity with them. And I go through the facts with the client and see, have you met all of the parameters of the contract?
Right.
Okay. Then next I look at compliance with federal and state law, because sometimes we have a scenario where you have a fully executed contract and people have complied with the provisions of the contract, but the contract doesn't comply with, or the developer or seller
To the state or
hasn't
federal.
complied with state law or federal law. And that would enable us, depending on which side we're
Right.
on.
Exactly, right.
Sure. If we're on the buyer's side, that would enable us to
Terminate.
rescind or terminate the contract. And then the next thing I do, which is kind of the most obvious common sense thing, is talk to the client. Being right is different than the cost of proving that you're right.
Right.
And so we really need to do a cost-benefit analysis. If we're talking about a $10,000 deposit,
It's not worth it.
split the baby, let's go home. If we're talking about a $100,000 or sometimes $400,000
Right.
deposit, that's a different kettle of fish.
Thank you for coming on the show, and thank you, audience. Thank you.